All right, sir, are you Robert Isaiah Paredes?
Yes, ma'am.
And Mr. Paredes, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. And so, Mr. Kimler, will your client waive the formal reading of the motion in each case?
You will.
Mr. Paredes, in cause number 16-24053, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 14th of 2016 for possession of a prohibited weapon, third-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
Cause number 20-35329, I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony, and that was also a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then finally, in cause number 20-35328, I also have a motion to revoke your unadjudicated probation. Shows you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony. That was also a 10-year deferred probation. Is that also correct? Each of these cases allege that you violated your probation. Count one in each case alleges that you failed to enter and successfully complete the JCDI program. Is that true or not true?
True.
Count two in each case alleges that you provided a urine sample June 12th, June 24th, July 10th, and July 31st that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
THC or marijuana.
True.
Okay. Count three in each case alleges that you provided a urine sample July 31st of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count four in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
You sure?
Well, I did one. I did two right before the month before I turned myself in. So
2 hours?
I did 2 days.
Two.
They said they were going to give me about 13 hours a day.
I think it's plead not true to that one.
Yeah, it should have been about 25, 26 hours.
Okay. We'll do not true for that. Count five in each case alleges that you failed to submit to alcohol or drug screening as ordered June 18th, June 25th, July 2nd, July 5th, and July 21st as ordered. Is that true or not true?
Not true.
Okay. Count six in each case alleges that you're behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true in each case to counts 1, 2, 3, and 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then each of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation. However, I'm going to reset your case so that the probation department can do an updated pre-sentence report. That'll give me more information about you, your probation, what's been going on. Also, at that hearing, if the state has any evidence with regard to those other counts, they'll be allowed to put that information on. Anything that you think is important for me to know, make sure you get that information to Mr. Kimler. He will present it to me on your behalf when we come back. These are unagreed. They're so let me make these notes and then. Brittany's mad. There's those. All right. So Mr. Kimler also filed a request that I set bonds in these 3 cases. There are currently no bonds set, is that correct?
I believe so, Your
Mr. Kimler, you may proceed.
Honor. Your Honor, I appreciate the fact that these are serious cases, 2 ag assaults with serious bodily injuries, and a prohibited weapon, which I believe was a short barrel firearm. I don't know whether it was a rifle or a shotgun, which I guess at first glance would be indicative of somebody's potentially dangerous to the community. I can only observe that the evaluation by the state, the probation department, and I suppose the court of these cases initially was that they were more worthy of deferred adjudicated probation. The finished performance on probation has not been sufficient. He's fallen short. I would observe that there are no allegations of any offense, but he has been remiss in taking care of his obligations. I don't know that he appreciates really the seriousness of what he's looking at in the event of a revocation. I could say that because he was somebody that's facing 20 years in penitentiary on an aggravated offense that can't refrain from the use of marijuana or THC, probably isn't taking their probation seriously, and doesn't fully comprehend the severity of what he's facing. I would ask the court to set bonds in these cases at an amount, hopefully, where he can meet those bonds in order to get out of jail and demonstrate to the court during the time period the court is waiting on the updated pre-sentence report that he can get back on track or get on track with his probation and hopefully perform community service through whatever evaluations that are necessary and demonstrate to the court that he can refrain from the use of illicit substances. Really, it's kind of an opportunity for Mr. Paredes either to demonstrate to the court that he has the desire and ability to complete probation or not, and he comes back to the court in 30 days and hasn't done anything on probation, then obviously the court would take that into consideration, could revoke him, give him up to 20 years of penitentiary on an aggravated offense. So it's really would be up to him, and I'd like him to have that opportunity
Well,
on bond to come back.
let me just stop you because Mr. Paredes has had every opportunity. Mr. Paredes was on probation for that prohibited weapon case, placed on probation in 2016. Then we have 2 new aggravated assault causing bodily injury indictments while he's on felony probation, and for whatever reason got another opportunity on those 2 cases at a deferred probation, has been given every opportunity. There was an MTRP filed. He wasn't revoked before. He was given probation, a deferred probation, which probably I did deferred on those so that if he did continue to violate, that I would have the entire range of punishment. If I had to guess, that's probably what my thought process was. Given an opportunity at JCDI where he was unsuccessfully discharged, where they're trying to help him with all of these things, I think based on all of that, the underlying offenses, the nature of the aggravated offenses, the fact that the first one had to do with a prohibited weapon, I do not think it is in the best interest of our community while he's out using cocaine, marijuana, getting kicked out of JCDI and on probation for these serious offenses, that he be given a bond at all. And I am going to find, based on the criterion 17.15, that it is not in the best interest, that even though this is a deferred probation in each of these cases, because there's 3, because there's 2 aggravated, that it is not in the best interest of anyone that he be granted a bond in any of these cases. There will be no bond in all 3 cases.
Yes, Your Honor, I would just urge in conformity with the motion that I filed for a speedy revocation hearing, that since the court's denied bond, we have a hearing, a dispositive.
We just had he just pled true, and so we'll get the updated report and get it set immediately after that.
I think it, Article 42A embodies an idea that there'll be a dispositive hearing within 20 days if the bond's reduced. That's my reading of it. So we would need to get an expedited PSI if there's denial of bond. That article, it's in the motion, the 20-day requirement if a bond's denied.
All right, let's get okay. All right, we'll get it set in 3 weeks. We'll set it for 3 weeks. Go back with the bailiff. All right, ma'am, you're Crystal Vogan. And Ms. Vogan, when you were here yesterday for sentencing, And cause number 25 DCCR 0026, just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is?
Yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, the court, for her actions yesterday. I did explain to her as far as where we were as the case, the rejection was there on the deferred. You did kind of put at that point, it would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but if she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited, we're going to leave it to the court, but we would not be inclined. We're on probation after where she acted and due to her criminal history. So we would,
Well,
if the court wants to allow her to do straight, that's fine. I understand.
yeah, well, that's what your argument was yesterday.
It was.
To continue, for me to go forward. So, I mean,
True.
the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday, and if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation, and then I can kind of reinstate everything up to the plea and all of that, so we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's fine.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change. And that's what everyone's agreement is. Is that correct? And it is, I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. All right, then what I'm going to do, let's see, restitution. And the restitution will be that 10,000. And that's everyone's agreement as well, correct?
Yes, correct.
All right, then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution, and to follow all of the rules and conditions of probation. If you do this, this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI, but y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay with the court, Ms. Bowman, I did want to apologize to you.
Yes, ma'am.
I'm very, very sorry. I was going through a lot, which I understand is not an excuse. And I do want to apologize for my actions and behavior.
I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, whatever, if you disagree, you disagree, but you have to do everything they said. You have to be cordial. Thank you for your apology. You can go back with the bailiff. Thank you. So we need you to email it before everything gets closed out. Good morning. You're Linton Arsenault? And Mr. Arsenault, are you currently sick?
Ma'am?
Are you sick right now?
No.
Would you pull that down for me just so, there you go, I can hear you better on the hearing. And Mr. Arsenault, in cause number 24, DCCR 2190, was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Take it out.
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
None from the defense.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time. The criminal trespasses that were all dismissed, all those. It looks, to defense lawyer, to me, it looks worse than it. I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got the minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to penitentiary. He stayed in the state. He stayed in county jail on that. That's my understanding, Judge. And I'm not making light.
On that case, he did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I bought everything in myself.
And I watched the interview, and it was confusing to me as to what he had to do. And I don't know. I think he probably just got frustrated and just didn't go the next time, next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to sentencing towards the lower end, Judge. I don't think 10 years, 10 years is a long time for him not reporting for that. So Judge, I would ask that you consider, he doesn't want a trial, he doesn't want probation. He said that he was upfront with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
All right, thank you. Mr.
Your Honor, I
Hoppower?
want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version, I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge, and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at, and if you aren't, then you're supervising yourself, and that's the problem. So The only reason I think the state, and it's up to the court, obviously, I don't agree with the lower end. I agree we have to know where he is, because if we rely on him to do it, he ain't gonna come. And he's not gonna report, so we need to do the maximum of 10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffpower. So, Mr. Arsenault, I noticed the same thing that Mr. Hoffpower did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part. You didn't say that?
No, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. When you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register, and you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I
sense.
went from Judge Stevenson. What is it?
No, you went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender. So you did know you have to register because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay. All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Reagan Benoit?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Benoit, in cause number 25 DCCR 0880, you're charged with the state jail felony offense of attempt to take a weapon from an officer from June 1st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 0881, you're charged with, let's see, are we going on the count 1 only in that case?
Is that the one within 6 months time?
6 months was on the weapon, it was 2 years on
This is the TDC.
This is the 2 TDC. I mean, but yes, Judge, we'll abandon that.
Okay, let me pull this up.
So we're doing 6 on attempted.
Yeah, 6 on attempted, 2 on assault.
Okay. All right, so in 25 DCCR 0881, the state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of assault on a security officer from June 1st of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Benoit is not competent?
No objection.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25 DCCR 0880, find sufficient evidence to find you guilty, and at this time find you guilty of attempt to take a weapon from an officer, sentence you in accordance with your agreement to a term of 6 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0881, I'll find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer, sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to in these cases we'll run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. And firearm is, I have to read the whole thing to you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You go back with the bailiff.
Thanks, Judge.
Yes, ma'am. Let me, thank you. Good morning. Are you Stephen, is it Bodwin? Bodwin.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Bodwin, in cause number 25 DCCR 0940, and so count one only and then to the lesser attempted, correct?
Correct.
The state's elected to proceed on count one only, and in count one to the lesser offense of an attempted robbery. That makes it a third-degree felony, and that's from June 24th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bodwin is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and then we'll come back later for sentencing. Miss,
I think he may have a parole issue, Judge.
He does.
We need to
oh,
check on. In my read of this, if this is the only thing he's dealing with parole, and my experience with parole, I don't anticipate that they would probably revoke him based on these underlying facts. But
Okay.
I think it would be best if we
okay,
maybe see
just
what
leave everything the same.
information we can get, and if we need to withdraw this and plead to something else, we can.
Okay, yeah, and if y'all can look into that and see if parole, have they already been out for a hearing?
Yes, ma'am. I had a revocation hearing on August the 19th, and they chose to reinstate my parole.
Okay,
But then when they brought the answer on August the 22nd, she gave me a new violation for the same allegations that I'm dealing with.
Okay.
Same exact allegations.
Okay.
They just voted on the revocation.
so they voted to revoke now, or
No, they haven't voted on
they
it.
haven't done it yet?
They did vote, and then in the same instance, she
Right.
gave me a new violation report.
Do you know when they're coming, you have no idea when they're
No,
coming to
ma'am,
do
I
that
was
again?
scheduled for a hearing last week, and she didn't show up.
Okay, if y'all will work to see maybe when that's gonna happen so that we know, obviously if they're gonna revoke you, it doesn't make sense to put you on probation. If they're not, then we can go forward with this, but we'll find out before sentencing. Okay, you can go back with the bailiff. Mr. Eaglin, in cause number 25 DCCR 0897, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from October 26th of 2024. Your indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, March 1st of 2013, in 2 cases on that same date of burglary of a habitation. And then after those were final, you were convicted of possession of a prohibited substance in a correctional facility, a third-degree felony, from September 3rd of 2015. What that means is that if you go to trial and you're found guilty and those prior convictions are true, you would be considered a habitual offender. The minimum punishment would be 25 years in prison up to 99 years or life. Do you understand? And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 20 years in prison, which means if you did that, I'm guessing that would be to just count one only. So you would only be pleading to the offense that you're charged with. And the most I could give you is 20 years. I could give you 20, I could give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to reject that offer and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, is there any reason to believe that that offer would change, Mr. Smith? So I do want to make sure you understand, Mr. Eaglin, that after today, unless there is new evidence that comes up that the attorneys don't know about already, I will not accept this plea agreement after today. Once your case goes on the trial docket, it either, if you plea, it's just something different, or we're going to let a jury decide. You understand? All right, so we'll get it set on the trial docket. Mr. Eaglin, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Lewis, you are released. We will appoint someone today, Mr. Eaglin. They should be out to see you very soon to begin preparation for trial. Okay, yes, sir. You can go back with the bailiff. Yes or no?
Yes, ma'am.
And so, Mr. Spikes, I'm going to reset your case because you're already on probation. It looks like there's a motion to revoke that probation coming. It's somewhere in the loop of getting that done. No reason to try to go forward on one case until we have both. I'm going to reset a normal reset. That motion should get filed, and Mr. Lewis will get all that information, and we'll see where we get at the next court date, okay? All right, you can go back with the bailiff. Good morning, sir. You're Dalton Batiste. And Mr. Batiste has 3 cases. Cause number 24 DCCR 0917 and 0918, both charged with murder, and the 24 DCCR 0407 charged with possession of marijuana. Case is set for trial to begin with jury selection Monday the 29th. And what is the announcement?
Still ready. Stay tuned.
All right, any changes or anything with regard to negotiations or?
Other than to say in such a complex case, I suppose that's always a possibility, but as of right now, no.
Well, I do want to make sure everybody understands that after today, unless there is new evidence, I will not receive, I'm numbering the cases after today. There won't be any plea agreements accepted, or it will be something different that he's rejected before, unless there is new evidence. It's likely to be towards the top of the list, if not at the top, okay? All right, so we'll see you back in a couple of weeks, then you can go back with the bailiff. And this one's going to be count one only, correct?
Yes, Your Honor. Judge, and I think you have the discovery certification, but you did that earlier.
I think I already handed it over there as well. All right, ma'am, again, you're Tracy Boyette, and will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Boyette, in cause number 25, DCCR 0941, the state's elected to proceed on count one only, and you're charged in count one with the third-degree felony offense of harassment of a public servant from July 1st of 2025, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney, you will be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Boyette's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with your agreement to a term of 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff. And you've got Taylin Douglas, Mr. Rojas. Good morning. Are you Taylin Douglas?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Douglas, in cause number 25, DCCR 0895, you're charged with the third-degree felony offense of obstruction or retaliation from June 5th of 2025, and how do you plead to that charge?
Guilty.
I'm sorry?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Those papers on the tablet that you signed, did y'all go over them?
Yes, ma'am.
And do you understand those papers that you signed?
Yes, ma'am. It's for probation, right?
Yep, it looks like. So do you understand if I follow the agreement that you made with the district attorney that
Can you
you'll...
read it to me?
I will in just a second. So listen to my question. If I follow the agreement that you made, do you understand that you've waived your right to appeal, which means if I go along with the agreement, you can't change your mind later? Do you understand that?
Yes, ma'am.
And it looks like the agreement that you reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. You understand that?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Douglas is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back.
PSI?
Hang on. A pre-sentence report is a PSI, so I'm going to get a PSI done, and that'll give me more information. We'll come back later for sentencing.
Judge.
Hang on. Ms.
My notes
Malfina.
indicate that he has quite an extensive laundry list of juvenile contacts with the law.
Okay.
I would like to reserve the right to ask for at least ISF cognitive to get him on the right track if the court thinks that's appropriate.
Yeah, you were born in,
That would
how
be
old
my
are you?
only objection
I'm
to
18.
Yeah,
PSI
okay.
bond.
So I'm not going to adjust the bond based on the age and the nature of the offense and the fact that there's some history I want to look at before we go through with sentencing. All right, so you can go back with the bailiff. Probation will come see you.
Judge, if we may, on this case, with court permission to proceed on the lesser included Class A misdemeanor of an attempted of the underlying offense. There's quite a bit of evidence possible in the file that there may be another individual with quite a bit of culpability who I don't know that they were charged. And she's been in the Hardin County Jail, and we just thought this was a fair resolution.
Okay, thank you. All right, ma'am, are you Teresa Taylor?
Mm-hmm.
And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Taylor, in cause number 23, DCCR 2120, the state has elected to proceed on the lesser included offense of an attempted fraudulent use or possession of identifying information, which makes that a Class A misdemeanor. And that's from August 15th of 2022. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
I am.
And because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State Tenders Number 1.
No objection.
It's admitted. Is there any evidence that Ms. Taylor is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser offense of attempted fraudulent use or possession of identifying information, sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. Good luck to you, ma'am. Thank you.
You just-
It is already. Okay. All right, sir, you're Jordan Thomas.
Yeah,
And Mr. Thomas, in cause number 24, DCCR 0487, you're charged with sexual assault of a child. And 24, DCCR 2178, you're charged with aggravated assault with a deadly weapon. Ms. Holmes has mentioned, last time you were here, there was an offer given. You wanted some time to talk about that or to think about it, and we reset it. And she said that your family now, are going to try to hire an attorney. Is that
Yes,
correct?
ma'am.
So here's the thing, your cases are very old, and based on the nature of that first offense, it takes precedence over a lot of other cases because there is a child complaining witness. I will reset the case one more time. If your family is able to hire an attorney before that court date, great, they can substitute in whoever that attorney is. If not, we'll need to go forward with your case with Ms. Holmes at that next court date and get an answer. Either you take the deal or you don't, we get it set for trial, okay? All right, do you understand that? Yes or no, please, for the record. Thank you. You can go back with the bailiff. Good morning. You are Ava Musgrove?
Yes, Your Honor.
And in cause number 25, DCCR 0048, Ms. Musgrove is charged with murder, set for trial to begin with jury selection Monday the 29th. And what is the announcement?
So, Your Honor, a couple of things. So, we just recently received an offer, or a new offer, from the state. There is a cell phone extraction that was performed a couple of months ago. It is a voluminous amount of material. We're still reviewing that. So if we could just have one more reset just to finish reviewing that, I think we're close to a resolution.
So why is it on the trial docket then?
Originally, that was, they said they didn't want an offer and wanted to proceed.
Right.
I think it had to do with the theory of their case.
Okay.
So because of this new offer, which we're heavily considering.
So here's what I'm going to do. I'm going to reset it. I'm going to take it off the trial docket. I'm going to reset it 45 days for a review.
Perfect.
And at that point, if there's something that gets worked out, it needs to take place on that day. Otherwise, it will go back on the trial docket and it'll be ready for trial.
Yes,
Is that good, Mr. Nichols?
Yes, sir.
Okay. All right. You can go back with the bailiff.
All right, thank you.
Just want to confirm, because his wife told me that, they had assigned him another counsel, but I've been hired on it.
Okay. Are you Tracy Boyette? And I'll need you to speak up, please, okay? Thank you. And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
I'm not sure, they just said it was another counsel, appointed counsel. Is my name on that?
Today.
Sorry, everything's moving slow.
At least you have a computer.
I do.
We're down to two.
That, oh, but as you say that, mine comes up with an error. Thank you, Mr. Rojas.
Luke, don't invite it.
An unhandled exception has occurred. If you click continue, it will ignore it. Let's ignore it. See what happens.
Handle your exceptions.
Nope, it's not letting me open it.
It's gonna be awesome on this Odyssey thing. Like, it's online, we're on there.
Oh, and now I just logged myself out completely. I don't know how to do that.
It's gonna be awesome.
I know. Yes.
Enterprise justice.
Can you get it?
No, that's not what I want.
Please, thank you.
All right, you want to try to, here,